Indiana, that over 30,000 hours of service was provided in 2023, and over 123,000 people were served in 2023. And with respect to the United Way of Central Indiana and its partners, over 94 million meals were delivered from 2020 to mid 2023. Quite an organization, and worth supporting. A couple items of housekeeping. Today's slides are going to be posted to the United Way of Central Indiana website, as will a recording of this webcast. So the slides will be available. We're going to try to answer some questions, and you'll see me leaning over here looking into the chat function. So I would encourage you to use the chat feature if you have some questions. And we will be happy to stay a few moments afterwards to answer some questions that maybe we can't get to. I do encourage you to put your questions into the chat feature and share with us some of the questions, again, that you might have. So let's get started. So you might be considering who might be the executor of your state. You might have already selected one, or it could be that you have been selected as an executor and are trying to figure out what the heck to do. So what choice do you need to think about when choosing an executor, and to make sure that the right choice was made? How do you manage and avoid risks such as unnecessary costs, litigation, and family strife? And we really hope to help you with all of that. We're going to walk through a number of different scenarios to provide you with a way of thinking, and hopefully that'll help you answer some of your questions, and hopefully we'll be able to answer some of your questions. So I think this is a good time to introduce our speaker, Rodney Retzner of Krieg DeVault, a very fine law firm headquartered in Indianapolis. His bio is in the materials that have been forwarded to you when we introduced the webcast. So Rodney, thanks for joining us.
Thank you for having me.
And you'll find that I tend to use the term executor, trustee, just a whole bunch of terms interchangeably. Is that right? Your thoughts on that?
Well, for this discussion, we got to pick a word. So let's use executor.
Okay.
But what you really get into is there are several different documents that individuals will have that will be their core planning. So most people will have a last will and testament. Some people will have a revocable trust. Then there's the documents that are necessary for when someone becomes incapacitated. So you'll have a general power of appointment for assets if you're incapacitated and someone needs to make decisions but you're still alive. And then you have a document for individuals who will make decisions for you if you have medical decisions that need to be made. And there are different names for each one of those. So if you're appointed as a fiduciary under a will, you're the executor, or a lot of times nowadays we use personal representative because it's gender neutral term. If you're the representative or the fiduciary in charge of a trust, then you're the trustee. And if you're under one of those powers of attorney, then typically you're called the attorney in fact. And if you're someone's guardian because you're taking care of someone's decisions as a court appointed individual, then you're a guardian. So they're all the different name for each one of the fiduciaries in each one of those positions. But we can say for today, we call it an executor, and that's fine. And we can use that, or we can, the broader term for all those positions is typically the fiduciary, someone with that legal fiduciary responsibility to be in charge of someone else's person or assets.
Okay, so somewhat interchangeable, but fiduciary being really the broad, the broad concept there. So as we think about some of the critical tasks that the one's really going to have to take on when you before you really begin to select a trustee or a fiduciary, what might be some of that homework that you really should have done before you start that process? And quite frankly, to the audience, if you haven't started, start now. What's some of that homework? What are some of those things that really need to be done before you start the process of thinking about who's going to be my fiduciary?
Right. The core input that you need when you go to visit with someone to assist you with this type of planning is a good solid list of what your assets are. What type of assets do you have? what type of ability do you have to pass those assets? Can they be jointly held? Can you add a beneficiary designation? All the different types of things you have, and you're typically, well, all the time when you're doing wills and trusts, you're going to be seeing an attorney to draft these things for you. And that attorney will want to see those assets, the extent of the assets, so they can talk to you about taxation, and the types of assets, so they can talk to you about titling of those assets and the appropriate way for those assets to pass to whomever you're going to have them pass to. And that's the core background you have to get. Then I also want clients, when they come to see me, I want them to have given some thought to who is going to be the person in charge of all this. It's a lot of times clients will come in and they'll say, I'm going to do all the stuff for my wife, and my wife's going to do this for me. And that's as far as they've given that thought, right? Well, odds are you're going to run out of people real quick in that line of succession. So you want to give some thought to who, or maybe if the professional fiduciaries like the banks and those types of individuals or corporations should be helping you.
That's very helpful. Regarding the complete inventory of assets, I am sure there are a number of interesting stories about people who haven't done the inventory, or people who have done the inventory and forgotten about a few things.
There always is. Always amazes me of, oh, I forgot about this asset that we had, and it's a fairly large asset that they just forgot to add to the list, and so you backstep a little bit and figure that out.
So the important thing is to clearly get started, and there's some homework that really needs to be done. So let's talk about fiduciaries. What are we looking for? What should the audience be looking for in terms of selecting a fiduciary, or if they've been selected a fiduciary, do they think they're the appropriate person to do that? What are some key things to really think about?
This is a job, for lack of a better term. It is not an honorary position. It is not something that should be done by somebody just because they're the oldest child. Or because you don't want to offend some of the other kids. It really is a job that needs to be done by somebody who has the time to handle the position. So if you're looking to pick a child, for example, and your child is practicing medicine in a city 2,000 miles away from here and working 40, 50 hours a week, that child, even though he or she may be the older child who you think should be doing it, may not necessarily have the time to do that type of thing. So time is clear, especially at the front end. In the front end of all of the administration of estates and trust, a lot of work has to be done in that first month and a half. And then there's some downtime after that while you wait for claims to clear and things of that nature. But that first month and a half after someone dies are really key. And it requires, it's almost akin to a full-time position for the first few weeks. So they have to have that time available. It also has to be somebody who's been around long enough to know what different things come up in life and what different types of assets people hold. So your child who graduated business school, who's 25 years old, may be good, have a good business background, but may not necessarily be the right person because they don't have life experiences yet. What we typically see when people draft documents is they'll start with older relatives, siblings or parents, and then as time progresses, they'll move into their children. But typically, you don't see children being able to serve until they're in their 30s, more realistically. They should also be somebody with a background in finance, some kind of, if even just managing their own assets. But if you have one child who's an artist and one child who's an accountant, you can kind of figure out which one of them would probably be a better role at doing the position that you're asking them to do, because they have to deal with taxes. They'll have to deal with potentially selling assets and possibly running a business and doing all those types of things. So you got to give that some thought. And if you don't have children or individuals family members that can serve, now you're getting into the trust level. Who do I trust the most among the friends that I have? And then there are always, and highly recommended, are the professional fiduciaries. They're the banks and the private trust companies, and certain individuals who have a skill set that they are actually professional fiduciaries should always be on your list of consideration as far as who should serve. And in fact, if you come into me and you have a list of 10 people you want to put, if this person can't serve, then this person, if this person can't serve, then this person, no matter how many people you put in line, I'm always going to put language in there that says, or the professional fiduciary who's selected by the beneficiaries. If we run out of people, then we need that professional help And I submit that professional person should be, or the professional fiduciary should be on the top of the list, at least as a co-fiduciary with the child.
Well, that's an interesting concept of making sure that you do have some professional that's on the list and that you're thinking about. I think what you're also saying is that this is not the time to be penny wise and pound foolish when it comes to
Correct.
expense. Spend a few dollars now, and what might you avoid in the future?
Yeah, so you will find with professional fiduciaries, they will come in, they've done it before, hundreds of times before. They'll drive the train, and they will give the proper disclosures, and there's a trust level that it's not another beneficiary doing it, it's some third party neutral. And usually you avoid a lot of litigation potential by having a neutral third party involved as part of the process. The trust level increases if it's somebody who doesn't have anything to gain from serving is in position. So
a very big point, quite frankly, a big takeaway for me. We really have one question that's come through here that's kind of interesting. Is it, and on the chat feature, is it typical and expected to pay the executor some amount taken out of the estate? If so, what's a good guideline or range? And I think I'll amend the question to say, what might be the answer for the fiduciary, say it's an individual, a family member, or whatever, and then what would normally, if you also have a trustee from a bank or something like that, what might that look like? So I'll turn that into a two-part question.
Sure. So the law is that any fiduciary serving is entitled to a fee for services, and they're also entitled to be reimbursed for the fees that they incur by hiring counsel to assist, an accountant to help with taxes, things of that nature. So if you say nothing in a document at all, the individual or the entity that's serving as your fiduciary is entitled to a fee regardless. Now, what that amount is, the law describes as reasonable. So what is reasonable?
Then the eyes of the beholder.
Right. So reasonable for a professional fiduciary, it may be reasonable for that professional fiduciary to charge $100, $200 an hour, or have a fixed fee where it's typically professional fiduciary will start around 1% of the total assets that they'll have to manage. And so that's been deemed over time a reasonable fee for them, but it also depends on what extent of the work is.
Mm-hmm.
For an individual, it's probably going to be less because they're not a professional. And so it will take them more time, and their expertise is lower. And so they would be at a lower rate. So when an individual serving, we typically marker off of that 1%, but it needs to be somewhere lower. And I always tell individuals to keep track of your time, just like I do. And then we look at the time that they put in, and we establish a reasonable rate for the expertise that they have, and we try and figure out what that rate should be. So for the corporate side then, so if you're an individual, establish a rate, keep track of time, and try and figure out what a reasonable rate will be, but they are entitled to it. A corporation, you're not going to get a neutral or corporation or a trust company to serve unless you pay them, because that's the function that they're serving. And again, typically you can think about a 1%, and then there's usually a sliding scale. The more assets you have, the lower the percentage goes. So that's what you can anticipate. But again, it's worth the fee because you're getting the expertise, and a lot of times the time frame and all the duties that have to be done go more like clockwork for those types of administration, because that's what they do all day long.
So if I'm functioning as a trustee or an executor and I just choose to donate my time, I can feel comfortable if I have to hire an outside firm to do a tax return, it might be of some expense. I should feel comfortable billing the estate for that tax return.
Absolutely. Absolutely. Any professional that you need to hire in the performance of your duties are those fees get paid out of the estate or out of the trust, whatever you're administering.
And if I choose to bill some personal time, I assume I could always talk with counsel to determine is this a reasonable amount so that you're not running afoul of things.
Yeah, most of the time family members will serve for free, but then they want their expenses paid. If they have travel expenses and things of that nature, they need to be reimbursed for those.
Okay. And I have seen some examples where a trustee all of a sudden has to get on the road, do quite a bit of work just trying to find some of the assets. If a good inventory wasn't taken, I know of some people where it's gotten to be pretty expensive. So you can feel comfortable charging your out-of-pocket expenses.
Yep, and you should anticipate if you're picking someone who's out of state or out of town, that they're going to have to travel here several times to make sure they gather everything together.
Okay. So with those, with that introduction as a backdrop, let's just jump right into some scenarios. I think
Okay.
we'll find that probably the biggest lessons are going to be are in these scenarios. So we have scenario one where you have a husband and a wife who are relatively the same age with no children, no other relatives, and the widow has not been involved with the financial management of the assets over time, not a lot of financial acumen. And what's your thoughts and advice on this scenario?
Yeah, so here you're
Fairly common, I assume.
it is fairly common. And here your Murphy's Law is that the husband's not going to be the survivor here, right? So the one who's not been involved with the finances, who doesn't have that financial acumen, is going to be the one who's left holding the bag and trying to figure out how to maintain a lifestyle while at the same time managing assets that he or she's never managed before. Here, what I recommend is that you've got to set up the team prior to something happening. And what I mean by that is there needs to be somebody, some professional involved with this couple now, financial planner, for example, or if the CPA that they have that does their taxes is familiar with their assets, is knowledgeable enough to help them with day-to-day funds and things of that nature, or even the attorney, if they have a good relationship with an attorney, can serve in that purpose as well. But the idea is to have somebody who's managing those assets for that couple, that the couple get to know over a period of time, so that when that husband dies, the wife has that trusted advisor that she's been working with for years, that she can continue to work with.
Somebody you can call for help.
Correct. And then here again, typically what you want to do in this scenario is it's okay for the wife to serve as the fiduciary here, but she's going to need some help. And so maybe you leave it open so that she can serve as a fiduciary, but then name that financial planner if it's allowable. Sometimes the SEC rules won't allow that, Securities Exchange rules. But typically a bank, there's a co-trustee or a co-executor with her so that she has the help she needs. Then she has help administering the estate. And then once the estate's done being administered, she still has that financial assistance that she has from that same professional that they've been working with for a long time. And that's the way to go here. What we typically see in these scenarios is something happens to the husband, the wife's left on an island, and then there's some neighbor or some friend from down the street who steps in to try and assist, just being the good person. And then a lot of times you'll see that good person has access to funds and becomes not such a good person, and does things that they shouldn't be doing financially with somebody else's money. So there's a risk. And that's why you have to involve professionals, and you have to involve them early.
Again, another example of spending a few dollars now probably saves quite a few dollars later. So let's walk to another scenario. We'll just ramp it up a little bit. So this is a case where there's a decedent that has 3 children, each with spouses and grandchildren. So it's a bigger family here. 2 of the children are financially stable, and the third child has fewer assets and perhaps has struggled a bit. The decedent has significant investment assets and owns a lake house. In other words, the estate gets to be a lot more expansive. What's your thoughts on that? Your advice?
So when you involve children, and especially if they're of a different financial ability, there becomes this elephant in the room, so to speak, about, I don't trust my older sibling because he already has wealth, and they're going to take what little I'm going to get from this inheritance from me. And so it's a higher possibility of what I call rogue child, someone who doesn't trust the system, doesn't trust what's going on, doesn't really have a good view or understanding of what's involved with what's going on. And when someone doesn't understand, then they don't trust. And so in this situation, you're better served again by having some neutral come in. That older sibling, or the sibling which of the 2 that you may name here as the executor or as the trustee here, you're putting them in a tough spot with respect to their relationship with their sibling, and you're putting them in a tough spot with potential litigation and so on. They can do it, and they will probably do just fine. But what's happening is you have a slow deterioration potentially of the relationship between that sibling who's serving as a fiduciary and that rogue child who may not trust that other sibling to be doing what they think they're supposed to be doing. In a situation like that, I keep harping and I keep going back to the possibility of this neutral third party being in the mix. But here is another good reason why there should be potentially a neutral third party in, at least as a co-trustee. So that if it gets too hot in the kitchen, that one sibling can step aside and say, okay, I'm out. And now we have a completely neutral party who's willing to do this, and let them take over. If you go through the natural succession of the one sibling to the second sibling to the finally get to the child who doesn't have the financial wherewithal, that can be even a worse issue, because now you have the child who doesn't have the financial acumen, who's trying to run things, who's paying themselves a fee, who doesn't understand the rules, so on. And so that can become a hotter mess than the first side. So that third party involvement is critical in all these situations, but here again, especially here, because you have that potential of misunderstanding. Now, the other thing that I will say here, and two other things really that come up in these situations, is if the child, if you're going to pick a child to run this situation or run this administration, then that child has to be full disclosure on everything they're doing. They cannot hide the ball on anything. Anything that gets hidden, that's where we're going to have litigation. If they're selling an asset, they should tell all the siblings, I'm selling this asset and here's how much I'm getting for it, and get input. They don't have to follow instructions from them, but they need to be disclosing all along the way what's going on. And there is a process by which you can make this a supervised administration so that they're actually getting court approval on everything. If we think our rogue child's going to be bad enough, then we'll just do a supervised administration. We'll start filing things with the court, give them their due process rights, come in and argue in front of the judge why you don't think we should sell that asset for that much, and then we sell it, and then you've got the flyover protection of the court on what they're doing. The other thing that interesting fact we introduce here is this lake house. So what happens here is everybody enjoys the lake house while mom and dad are alive, because nobody's paying for it. It's not coming out of their assets. Once you have this lake house, it introduces a whole nother layer of potential strife between the children after mom and dad are gone, because here now you have an asset that has to be maintained, and it has to be maintained by the children's assets once mom and dad are passed. With the child that's not financially as well off as the other two, when the roof needs to be fixed, that child's not going to be able to step in and put money back in to repair the roof. And if something else needs to happen, even just general use and paying utilities and things of that nature, you're setting them up for constant battles underneath what happens with the lake home. So if they're going to keep that place and they're going to use it, a lot of times what we'll do is we'll have an ongoing trust just for that lake home, and we'll fund that with part of the inheritance coming from mom and dad, and then you'll put the children in charge of running that as more like a company, and for the use of everyone rather than just an individual use like they were doing with mom and dad.
So if you've been selected as a fiduciary, then you have the bank perhaps as a trustee. As a trustee, you can march down the path, start to administer, do the things you need to do, but you could use that co-trustee, the bank as a bit of a sounding board, and especially if things get very difficult. So you could call the trustee and say, this has happened. What do you think? And you've got a good sounding board.
You've got a good sounding board. You've got someone who has to make decisions with you because they're a co-trustee with you. And trust me when I say this, the professional fiduciaries are not going to make bad decisions or even risky decisions, because they are a deeper pocket that could be liable for a bad decision to be made. And they have all the experience as well. So when a decision has to be made on just about anything you can come up with, that professional fiduciary is going to know what the right answer should be. And you can also use them as the bad guy. Oh, brother, I would make that distribution to you, but
yes,
that's what I can't. So
that's a good point. There's another question that came through, and is it okay to name two co-executives?
Absolutely, it is. You just have to be mindful when you're naming more than one individual as a fiduciary. The law provides that they have to act by majority. So if there's two of them, then every decision they make, they have to agree on. Now they can delegate some decisions from one to the other, but they have to agree. If you have three, then two of three can outvote the third. So That's the system in the law that is set up when you have multiple fiduciaries. However, you can get around that system too. If you want two kids to serve for convenience purposes, but you don't care which one makes the decision, you could say, I name these two as co-fiduciaries or co-trustees or co-executors, but either one of them can make the decision on their own as they're performing their duties. And that's a little risky because you end up the left hand not knowing what the right hand's doing in a situation like that. But you can design it that way if that's the way you want it to be.
Whoever sent that question, thanks for sending that question. That's really, really, really good point. So let's walk to scenario 3. So the decedent owns a business, a home, and some other investments. And there's 2 children, one of whom is a special needs individual needing some ongoing and long-term care. So, introduces some additional complicating facts and some thoughts and advice on that.
Well, we've introduced a business, so now we're really stepping up our game because we had a estate and trust administration, and now we've got a completely separate legal entity that has to be ran and set up to function and continue to function, because now we're talking about other people's livelihoods rather than just family wealth. But before we talk about the business, that special needs individual, the planning for that individual needs to occur even more so than the planning for the business and the home.
So that's the first thing to attack.
First thing to attack would be that special needs individual, especially if mom and dad are the current guardians over that individual. Because what you're doing in that scenario is you have to plan for that individual and how that individual is going to be cared for, separately from who's going to be your executor and who's going to be the trustee of funds, who's going to be providing for the welfare of that child. Who is going to step up? Is it going to be the sibling who will step up and be the continuing guardian over their sibling? May or may not be. They may not have the wherewithal. They could be living their life 10 states away and raising 5 kids and not have the time to deal with the individual. Is there a home that the individual will go to, halfway house or something of those nature? And how do you get them in? And can you set that up in advance of your death so that it's all set to happen beforehand? But the key there is in addition to selecting fiduciaries, you have to select who is going to be the guardian over that supplemental or that special needs child, that individual, and who will step up. And I would submit you need a backup and maybe even a backup to that person, because people will say, yes, I'll step up and help take care of him or her. But when the time comes and they actually have to be installed as guardian, they may have a different change in life and they may not be able to serve. And so you need to have several individuals as backup to serve for that person.
So your point is, with a couple exclamation points, solve it first.
Let's solve it first.
Okay.
Yeah, you need to set up, and then we can talk about the funding for the lifestyle for that special needs child, because then in your planning, you're going to have, once you've figured out who the individual is going to be and what the life plan for that individual will be, then you can back into the funding for where the asset's going to be. How are we going to put assets in trust for that individual and maintain their lifestyle? Then you step back over to the business and the home and the investments. So where we were talking earlier, we were talking about someone who has financial acumen and someone who can assist in the administration of that. Now you're doing that on steroids, because now you have to have someone who has some type of business experience in running those assets. And here is a good scenario where we typically will see, if not co-trustees, advisors. So you will name fiduciaries in your documents and you will have executors and trustees like we talked about. But there's another layer that we can add to the fiduciary positions, and those are advisors. And in a scenario where you have a business, if that other child is not in that business and running that business and knows nothing about how the business should be done, there we should have someone who is there on a day-to-day basis, who is helping run that business, be a business advisor to the trustee. So now that child could serve as the executor or the trustee, but then have that advisor in place who will direct them as far as, we need to sell the business, or we need to install this for the business to continue, or we have to find a new CEO, or whatever the matter is that comes up. How do we keep that business functioning until it can be back to a running business where mom or dad were running it before at the same level? And so that business advisor role is an important thing that can step in and assist.
Yeah, and I will say in my years of working at Deloitte, I saw that specific step done well, and I saw it done not so well. And it is very, very important. And that's the concept of having somebody in that corporation who can really help run that business.
It is, and it's, sometimes we have a team of advisors. So sometimes you'll see someone from the business, you'll see someone who is a certified public accountant, for example. Maybe it's a team. And so a team of advisors then gets together and basically holds a board meeting before the board meeting to decide how the decisions should be made with respect to that company. But it does step up the complexity of what you have going on. And it's a whole nother, if you own a family business and your anticipation is that that business will continue after your death, there is a whole nother type of planning in this area called business succession planning. And it's not just wills and trusts. There you're talking about who are your key people and how do I incentivize those key people to stick around after I'm gone and not just cross the street and start their own business to compete against me. And so there are a whole bunch more advisors and a whole bunch more of individuals involved rather than just an executor and a trustee. Ultimately, that executor and trustee is going to be calling the shots because they're going to be the fiduciary that owns the stock or the interest in that company. But they need to have that team built around them before you go so that they're not left adrift and not knowing what to do with the company.
Very good. Thank you very much. And I would reiterate that the lesson that you've given us on scenario 3 is address the special needs of that one child and address it first and tackle that. It is important. So
You bet.
the next scenario is, we'll ramp it up a little bit, and this is a couple that's decedent and divorced and is remarried with children from both marriages. I could see that getting complex on almost geometrically at some point in time, depending upon the size and the number of people. But some comments and thoughts on that, because I could see that being a bit of a trap, so to speak.
So in my profession, we do drafting of documents, wills and trusts, and so planning. We do administration, and then we do litigation. So I can tell you without reservation, the scenario you have here is the #1 fodder for litigation. It is the #1 driver for a trust and estate litigation is a subsequent spouse being involved in the estate or trust administration of someone else's parent, and that spouse is not the parent of those children. So you just set them up automatically for a battle here. And it has to be above board. Everything has to be done correctly. Once the administration of the estate is done, you'll typically have a continuing trust for that surviving spouse, which the children will be beneficiaries of. And so there's a constant battle between how much can be distributed to that spouse without causing the children from the deceased spouse's marriage to be fighting against them for what he or she's getting. And it's on and on and on and on. And it will continue for the duration of the lifetime of that second spouse. So you're here again, what you will see is, and I keep harping on this, and I know that I do, but this is another situation where an individual third-party trustee, not somebody from either one of those families, but a neutral steps in and drives the administration, drives the trust administration for that surviving spouse, the continuing trust for that surviving spouse, and makes those decisions in their best judgment as to when distributions should be made. And so now, what I have seen done before, if both sets of those children can get along with one another well enough, we've devised systems before where we have one fiduciary from each set of children. So dad passes away and there's a child from dad's kids and there's a child from mom's kids who are the co-trustees and the co-executors in that scenario. And there you have a representative from both sides of that family, both sets of children, who are doing the administration, check and balance against one another. And when a continuing trust is in place for the wife in that scenario, there are two individuals, one who's for mom and one who's not necessarily for mom, and for the remainder beneficiaries who will inherit when she goes. And they work together if they can get along. That greatly depends on the family. It depends on if it, the Brady Bunch where the two sets of kids were raised together, or is it a scenario where, where dad married someone who was 20 years his younger and dad's children are 20 years older than the wife's children. The scenarios are boundless in that situation about how you're going to figure this out. But again, that neutral third party executor or trustee are typically the way to at least involve them in this to prevent that strife from happening.
And help give you a bit of a roadmap on how to solve these issues or potential issues.
Yeah. Now there are all kinds of ways that a good fiduciary, if they know what they're doing, can minimize any damage between family members, those two sets of children as they go along. If there's typically what you end up with after the estate's done and the trust is established for the surviving spouse here, you have a constant battle between the spouse needing more income out of that trust and the children wanting those assets invested for growth rather than income so that they get a bigger inheritance when she passes.
Interesting.
Right. And so a good fiduciary, someone that knows what they're doing in that scenario, knows that they can do a unit trust conversion, for example, where instead of arguing about how to invest, they just say a fixed amount of the principal of this trust is to be deemed as income, and that's what we're going to pay out to the wife, and then the rest just grows, and that frees up that fiduciary to invest how they think they can invest the best, and not worry about am I producing enough income or am I not producing enough income, etc. Right, and then also a good fiduciary will also. There are limitations on what the spouse can get from a trust like that, and so the limitations are typically as he or she needs them for, the standard terms are health, education, maintenance, support, right? And so a fiduciary will ask her, that surviving spouse, show us your budget. What are your needs? Why can't you meet those needs from your assets over there rather than pull them out of this trust, which benefits, a different set of people? And there's a constant battle there. If she uses her assets over there, well, that's draining the inheritance of this set of children. Right. And if she uses the trust, it's draining the assets for this set of children. And so how do we balance all that? And there I will tell you, putting those kids in that situation is probably not a good idea. Even if we have a balance where it's one from each set of kids, there's going to be a constant battle. Thanksgiving is going to be a terrible experience every year. Christmas may not be that good, so on and so on, right? And so you need to relieve them of some of that tension by getting that third party involved.
Very helpful, very helpful. So we've covered we've really just covered a heck of a lot. We've gone through a number of different scenarios, and feel free to put your questions that you might have into the chat feature, and we can still have time to answer a few questions. But so again we've covered a lot. So what are some of the key takeaways from what we've discussed today? As people are sitting there and perhaps their mind is a little filled with facts and they're nervous about a few things. What are some of the key takeaways as we might summarize this?
Sure. We've talked a lot about a neutral being in a bank or a trust company being involved. I am not adverse to having individuals serve as fiduciaries, not at all. They are typically the individuals that you trust the most. They're typically the individuals that know the most about your lifestyle, what your intentions would have been in the planning. If there was some asset you wanted to go to a certain individual and you didn't quite lay it out, typically one of your children would be the best person to remember that daughter Susie should have had this particular asset rather than Jimmy and whatever else. And so they know everything there is to know about you. But when you're picking those individuals, you have to make sure it is that child or that individual who has that knowledge of you and your background. When we get into those dicier situations where we can see that we're setting them up, like the situation we just talked about with kids from different marriages and the family business and all those types of things, that's where I really try and push individuals to involve that professional fiduciary, that neutral third party. And it doesn't necessarily have to be mandatory, but I would at least draft in your documents the possibility of allowing those individuals to be able to name that neutral to serve with them, to allow them to get the help that they need. And some banks don't necessarily have to be named as a fiduciary. Sometimes the child can name them as an agent, and the bank will come in and do all the back house work for the individual, do all the accounting work,
The tax
do all
tax
the
returns,
tax
that would be a
returns,
blessing.
everything else,
Mhm.
right? And just leave your appointed child as you know, the lord of the manor to say, yes, that looks good, and yes, that looks good, and then but relieves them of all the day-to-day operations of the things that they have to do. So really think hard about getting them driven in that direction. When you get the higher end, the business assets, things of that nature, we really want to think about third-party advisors who in that business can help us with the advice, and the CPA, and even the lender who's doing all the lending to the business, involve the lender in what they think the decisions ought to be, and give them a say in how things are going with respect to that. So that's selection of the trustee. That inventory of assets is critical.
And there's a question that's come up. I might just interrupt because it relates to this. I think, is that how can this person or how can I facilitate things for the trustee? And I have this sneaking suspicion that making sure a good inventory of assets, so they don't have to go searching for everything, is step number one. So I'll answer that question, but I think that's probably the first item on the slide.
Yeah. So the inventory of assets, let's go back to that just real quick, because how you set things up and help that trustee out is driven by that trust document. If you have specific things you want that trustee to do within reason, you can draft those instructions in the document. I always advise clients, though, to be a little loose on specific directions, because you cannot anticipate all of the possibilities that may come up. So you may say, when I die, sell this asset immediately, but it may be a down market for whatever that asset is. And that's not necessarily a good idea to do, right? And so give them direction, but leave them flexibility for that. Inventory of assets, though, is key here. What clients forget, and what we have to remember, is your executor is only in charge of assets that pass through probate. Your trustee is only in charge of assets that are owned by that trust or that pass through that trust. So when we're doing this inventory of assets, if you come in and we've drafted this nice will and trust for you, but all of your assets have a beneficiary designation on them, well, then we've wasted our time with the will and trust, because those assets are not passing through either one of those two documents, and they are not under the purview of your executor or your trustee. So we need to look at those assets. Here is my retirement account. Who's named as the beneficiary in that retirement account? Here's my investment account. Who is the beneficiary or the owner of that investment account? Here is my home. Is that transfer on death straight to my kids, or is it owned by my trust to pass through my trust? And on, really. So you have to take a look at each asset, whether that asset has beneficiary designation, can be transfer on death designated, or whether it's just owned in someone's individual name. And after you put these documents in place and you've selected who this executor is, you have to go back. And the important second step, almost more important than drafting the documents themselves, is have I aligned each one of these assets then to pass through the will or the trust, whichever one of those is going to be my governing document for where I want my things to go.
So the lesson for the audience would be, make the inventory of assets. Don't get writer's block, because there are a number of different questions out there. Where is the title? Where should it be titled? At least start with a good listing of the assets. Use your team to help you determine, and they can find out where it's titled, how it's titled, how it should be titled.
Absolutely.
But at least get the inventory.
At least get the inventory. And if you can't find titles and things of that nature in today's days of computers, we can find titles to homes online. We can find titles to cars online. I mean, all that stuff, we can figure that out.
So don't let those complexities stop you.
Right.
Make the inventory.
Exactly. So then we also, the rest of some of these key takeaways. So the third one there, where the legal documents are stored. Okay, this is becoming more and more important in today's day and age, because you don't turn on a computer nowadays without having 15 to 16 to 100 different passwords. You have a different password for every place where you invest. You have a different password for where you buy tickets to concerts, a different password, and on, right? So your family needs to know all of my stuff are in these particular areas, and here's my current username and my password. Now, someone will tell me, I've been told I'm not supposed to write that down. I can't tell you whether that's a good idea or not. Some people will say I use a password protection group, and so I get online and all my passwords are under that one password entry, but then somebody steals that password and then they got them all. And so I can't tell you what the right idea is, but all I can tell you is somehow between you and your family members, you have to let those individuals know where your stuff is, what websites you have to go to, what the passwords, what the usernames are for all those things, and keep that information with those documents. The other thing I tell clients all the time is I don't necessarily need you to provide copies of documents to the children who you have named in the documents. Tell those children where the documents are. The downside of providing copies to everyone is you may change them. You'll come back in and you'll change your documents, and then you pass away and we have a whole new set of documents, but you have a child who's looking at a set of documents that they think are the ones they're supposed to be using and they're not. And that confusion can cause problems. So let the children know where they are. Don't put them in a safe unless the children know the combination to the safe, right? Because we've drilled in my career, we have hired locksmiths to drill probably 15, 20 safes. So it's just a matter of no one can find the keys. And so we got to get in the safe because we think that's where everything is.
So I'm going to interrupt your train of thought here for a second, because a couple of questions have come in that are very relevant to this concept of I'll call it professional advisor or help. Well, first one is how does one go about selecting the right third party fiduciary? And then this another question is that in selecting a professional fiduciary, are there particular credentials we should seek? And you know, if I could just scroll down a little bit information on fees and how you might distinguish on fees.
Yeah.
But the important one is how do you select the right one? How do you go about it? And
yeah, so the key here is to develop a relationship with them. When a client asks me if I'm looking for that neutral, that third party fiduciary, how do I decide? And we always start with, well, where do you bank? Who's the bank that you currently have a relationship with, or where your investments are? Where do you have your investments? And dig deeper into that institution. Ask that institution who does the administration of, and typically it's a trust group or it's a private wealth group in that particular institution. Who are those people? And then go meet them. Interview with them, see if you trust them, get them involved as much as they have time to get involved with what you have going on. Now, they may not have too much time to do that with you, because if you're not an active client, they have active work that they have to be doing for paying clients, but they will give you time to be able to talk to you and tell you how they'll tell you how their fee structure is. Most of them will have marketing material that they will send out to you to tell you how they work with your children or your family after you're gone. They'll tell you the fee schedule, because they typically all post fee schedules as to how much they charge. And so all that information is readily available. And if you ask them, they'll give you every piece of information they have, because they want you as that client. They want you to trust them, to have those assets with them. Now, how do you pick the good ones? I will submit to you that if they are in business and they do a regular flow of this type of business, they're good, because if they're not, they wouldn't be around. So, and there have been trust companies in the past who didn't provide good service or did things the wrong way, and they are no longer in business. So if they're around, they probably do a good service.
will that person typically charge then an hourly rate, or is the percentage, the 1% you refer to, is that for the wealth managing of the assets, or could the basic fee be a combination of both?
Well, so typically you won't be paying that professional fiduciary until they're called on.
Okay.
So you can name them in a document, and they will be the fiduciary when you're no longer with us, but they are not charging that fee until they're actually called upon to serve.
Okay, that's an important point.
So all you're doing is their willingness to step in when you've passed, and for the fee that they've set up. So that's where you're going, and really it's really has to be your field. Develop a relationship with them and decide if those are the people that you trust. And really, with the understanding of the institution itself is more important, because you may meet a trust officer today that you really have a good rapport with, but you're not dying for another 20 years. And will that person still be there? So how good is that institution at this and hiring the same type of people?
Another question that's come in is if you're a legal guardian, is it mandatory to have an additional fiduciary?
It depends on how that's set up. So when I am if I'm serving as legal guardian for someone, minor or incapacitated person, typically I will be the guardian of the person and guardian of the estate. Guardian of the person is like being a parent. Buy them clothes, where do they go to school, where are they living, those types of things. And guardian of the state is someone over the assets that individual receives. So if they have an income from Social Security, for example, or from a trust, for example, how those assets get spent. But there may be a separate trust out there for the benefit of that individual. And there you do have to have a separate trustee running those assets for the benefit of your protected person.
So that makes that a very relevant question that came through.
And it's how it's set up, right? If I died today without a will in place and I had minor children, which I don't, but if I died today without any will in place and just left my assets to my minor child, there would be a guardian, and the guardian would be in charge of both that child and that child's assets. If I died, however, like you should have it set up, and I left assets in trust for that child, then that guardian is just going to be where that child lives and, you know, where they go to school and things of that nature. And there's a trustee that's going to be running the assets, investing those, and getting the income to that guardian to take care of the child.
Okay. Well, thank you for that question. I got you diverted from the list of the key takeaways. We have, looks like we have about 10 minutes.
Okay. We talk about informing fiduciary of who the fiduciary will be. This is especially true in some of those scenarios where we had a business involved and we had different complications. We sometimes will have a family meeting where we'll sit down with mom and dad and the different family members, and we'll describe to the children, we're not getting their input. It's not a meeting where they get to make decisions. It's a meeting to inform them of the decisions that have been made. And so we'll sit down with that family and we will go through, this is where the assets are going. This is what the shares are going to be. This is son number one or daughter number two, or whoever it is that will be in charge of everything. If you have any problems with this, I want to hear them now, but this is my design and this is why I'm doing it this way.
Mm-hmm.
And we'll go toward a family meeting like that. That is especially common if you have a business here in Indiana, the business that typically doesn't pass equally to the children as a family farm. Typically you have 3 or 4 children and one of them's been farming the ground. And so mom and dad want to keep the farm in the family. And so that individual gets farm ground and the rest of the children get something else.
Mm-hmm.
You're talking a big disparity in inheritance when that happens. And so there typically does have to be a family meeting when that happens, because the first time those children find out that their shares aren't going to be equal should not be after mom and dad have passed. It should be while mom and dad are alive. Mom and dad can look them in the eye and tell them why the shares are different. We have it in family businesses all the time. There'll be one child who's running that family business who is responsible for the growth and the value of that family business. And the decision to have them be the executor and be in charge of that business and get a bigger share is because that business has grown because of that child's involvement. So that's why their inheritance is going to be different. But you want to disclose all that stuff up front before mom and dad pass away so that there are no surprises when that actually occurs.
I'm hearing a theme here of transparency and disclosure.
Absolutely.
So, okay.
Absolutely. And then the last point we had on there was review your plan every 5 years in significant events. Your crystal ball, when you're designing the plan and you're picking who these people will be to run this plan, your crystal ball can only look out a maximum of 5 years. The world changes around us, whether we're changing or not. And the decisions you make today and the people you pick today in 5 years can be dramatically different. You may not even be living in Indiana, for example, anymore, or your assets may have gone down to half of what they were, or maybe increased tenfold in a 5-year period of time. And so what you have going on is a constantly changing thing. And it doesn't hurt to sit down with your attorney every 3 or 5 years, whatever it may be, and just spend an hour, again, time well spent, spend an hour with them to review what you have in place, what your assets are, to make sure that everything that you put in place is still what you want. And if you don't have to make any changes, well, at least you walk away from that meeting with peace of mind that it's still a good plan and I don't have to make any changes. But lots of times people will come in and we'll have that meeting like, oh my God, why did we make that decision? That just doesn't make any sense. And so we'll be making some changes.
That is an important lesson. Another question that has come in is if you're the legal guardian of an adult who no longer can care for themselves and make decisions, then do you need an additional fiduciary?
But well, again, legal guardian is the one where we're talking about they're in charge of where that individual is,
Right.
what facility they're in. For example, I was meeting with a couple yesterday, and somebody had to be the guardian over those individuals to put them in a memory care facility, right? And so somebody has to be able to make those decisions. Now, have to have a separate fiduciary in charge of the money. It's not a have to, it's an advice type of thing. You want somebody, I always want to keep those duties bifurcated so that I don't have someone in charge of the individual who's spending the money, who's paying themselves a fee unchecked by anybody else. So, you know, and so that third party or that other individual then who's in charge of the assets can be that check and balance that we have. It protects against something bad happening to these individuals and their assets, but it also protects the individuals involved. I don't want to be the guardian who's in charge of individuals' assets and also has to answer all the questions of where the assets are being spent and also has to keep track of how those assets are invested and be the one accused of doing something wrong and nobody to be able to defend me but me, right? So that check and balance system works in everybody's favor.
Good advice, a very good point. One other question that has come up is, and this is somebody I think is maybe thinking about pulling out a fee, but is that, and I don't know the answer to this, here I'm a CPA, is the income that's, if the fiduciary charges a fee, is that ordinary income?
It is.
It is ordinary income. There you go.
Yeah.
I didn't know.
So there is especially if if the state's larger and it's going to be taxable for federal death tax, federal state tax, that's a 40% tax, right? And a fiduciary serving is going to be paying income tax on assets. And so there's a tax play we go back and forth with. Why would I inherit these assets at 40% when I could charge a fee and pull assets out of ordinary income, which would probably be lower and deduct off of the amount that I have to pay on the federal estate tax? And so there's a tax balancing act that we try to do there in those situations. On the other side of the coin, if the estate's not taxable and I'm one of the children and I'm serving as fiduciary and I'm going to inherit all these assets from my parents without paying any tax,
Why charge it?
Why charge a fee and pull assets out and pay tax? So there's that.
Interesting point. With that, I think we're really to the end. Any final comments or advice?
Yeah, well, I hope it was helpful. I hope I didn't confuse you more than we started with, but it requires some thought and some time spent with your fiduciary or with your professionals discussing your situation. Every situation is unique. You can't just do this with forms and throw words on paper. You have to give some considerable thought to this. Otherwise, the expense that you're avoiding today, you'll spend way more than that after if you haven't given it good thought and spent some time working on it.
Well, thank you, and thank you for your expertise and sharing that with us. And also thanks to the United Way of Central Indiana for sponsoring this, as well as the Senior Academy of IUPUI. There's a lot of material, a lot of information here. It can get very complex very quickly. And hopefully what we've been able to do through some scenarios, and we purposely gave you some scenarios, was to give you an idea of how to perhaps think through and answer some of the questions that come up. But I think there was also a clear message out there is that don't be shy about hiring someone outside to give you some help. Yeah. Have a team. And I think the other lesson is have that team that in case something happens, the spouse, the family members, have somebody to call right away to help solve the problems and ask for help.
Exactly. Yeah.
With that, again, thanks to the Seniors Academy IUPUI and United Way of Central Indiana, and we are adjourned. Thanks for joining us.